Thank you. Mr. President, members of the Court, good afternoon. As adverted this morning, I will address you on the nature and reliability of the Gambia's evidence and the weight that it merits in your deliberations on whether the Gambia has proven its case that Myanmar committed genocide against the Rohingya people. The evidence itself will be presented by the speakers who follow me. My job is to explain why you should regard this evidence as trustworthy and convincing and give it the weight that we say it deserves. As a preliminary matter, Mr. President, you may recall that I cut my morning speech a bit short in the interests of time. I will be including two excerpts from that speech this afternoon, and for the benefit of the esteemed interpreters, these inserts will come in paragraph 8 of the current speech after the third line, and again after paragraph 36 of this speech. Mr. President, our case was filed in November 2019, shortly after the publication of a report in September of that year by a United Nations fact-finding mission appointed by the Human Rights Council and endorsed by the General Assembly. This was the second such report prepared by the FFM following its initial report of September 2018. Together, these reports comprise more than 600 pages and provide, inter alia, detailed descriptions of the so-called clearance operations carried out by Myanmar's army, the Tatmadaw, in northern Rakhine State, where the majority of the Rohingya group lived. In conducting their investigation and producing these reports, the FFM interviewed 1,294 victims, witnesses, perpetrators, and former Myanmar officials. They also reviewed satellite imagery, video and photo material, as well as internal documents, laws, policies, and directives of Myanmar. Taken together, the FFM's two reports appear to be the most voluminous, comprehensive, and detailed investigative reports ever produced by a United Nations fact-finding mission. These reports confirm the Gambia's conclusion that Myanmar had committed genocide against the Rohingya Muslim group and that there was a compelling need to hold Myanmar accountable under the 1948 Convention by bringing these proceedings. After this case was initiated in 2020, the UN Human Rights Council established the Independent Investigative Mission for Myanmar to follow up on the FFM's work. According to its mandate, the IIMM would do so by collecting, consolidating, and analyzing evidence of the most serious international crimes and violations of international law committed in Myanmar since 2011, and to prepare files in order to facilitate and expedite fair and independent criminal proceedings. To this date, the IIMM has published 6 what it calls analytical reports, which are all part of the record of this case. And it has produced 41 witness statements, of which 12 have been introduced into evidence by the Gambia and 18 by Myanmar. Also part of the record is the affidavit of Assistant Secretary General Nicholas Koumjian, the head of the IIMM, in which he describes the mechanism's mandate and the work it has performed to date. The Gambia's evidence also includes reports from other authoritative United Nations bodies, including the Office of the High Commissioner for Human Rights and the Special Rapporteur on the Situation of Human Rights in Myanmar, as well as satellite imagery from UNISAT, the UN Satellite Center. The Gambia has also submitted no less than 50 reports from experienced and highly credible non-governmental organizations, including the United States Holocaust Memorial Museum, Médecins Sans Frontières, Amnesty International, Human Rights Watch, Physicians for Human Rights, Save the Children, the International Crisis Group, and Fortify Rights, as well as a report produced in 2018 by the United States Department of State. Not least, the Gambia has submitted 48 signed witness statements from victims and eyewitnesses providing first-hand testimony of the events surrounding Myanmar's clearance operations in the Rohingya villages of northern Rakhine State. In 14 of these, the names have been redacted at the request of the witness, who expressed fear of reprisal by Myanmar against themselves or family members remaining in the country. Names do appear in the other 34 witness statements. 3 of the witnesses will testify here next Wednesday and Thursday. We place special emphasis on the reports by the FFM and IIMM, including all of the underlying material on which the reports are based. While the rest of our evidence, including the witness testimony, is highly probative and significant in itself, its value also lies in its consistency with and confirmation of the findings of the FFM and the IIMM, which serves to underscore and enhance the reliability and weight of the FFM's 2 comprehensive reports and the IIMM's 6 analytical reports. All of these reports, from the FFM and the IIMM, from UN, OHCHR, and the special rapporteurs, from the NGOs and the United States, as well as the witness statements, corroborate one another and provide strong assurances of the evidence, reliability, and convincing nature. We submit that all of these reports come from disinterested third parties, especially those from United Nations bodies. They should be given significant evidentiary weight by the court in determining the facts of the case for this reason. Myanmar disagrees. It has 3 words for all of these reports and statements, quote, no evidential weight. They argue that our evidence should be rejected in its entirety by the court because none of it arose from judicial proceedings such as those conducted by the ICTY, cited by the court in the Bosnia and Croatia cases. For Myanmar, the court cannot rely on the reports of the UN fact-finding mission or of any other independent and authoritative non-judicial entity without, in their words, delegating its fact-finding responsibility to such third parties. Mr. President, it doesn't take a Newton, Professor Michael of Vanderbilt, or Sir Isaac of the English Enlightenment to appreciate the lack of gravity in Myanmar's argument. With the evidence so overwhelmingly against it, Myanmar has no choice but to invent a reason, no matter how unreasonable, to disqualify that evidence. Myanmar has got it completely wrong. In fact, the court has regularly relied on the reports of independent fact-finding bodies, especially UN bodies, to assist it in its own determination of the facts. To be sure, as its jurisprudence makes clear, it has done so only after carefully scrutinizing these reports to ensure that they meet the standards articulated in its case law for establishing their reliability. Doing so here would be consistent with the court's long-standing practice. Earlier today, I cited some examples, including the court's express reliance on the report of the Secretary General in the Bosnia case, and the consideration it gave to the special rapporteur's report in the Croatia case. In fact, the court's jurisprudence is replete with examples of its reliance on independent and authoritative reports from United Nations bodies and from other highly credible third parties, including other international organizations and NGOs, in finding the facts of a particular case. A brief tour through that jurisprudence demonstrates the Court's consistent approach to this kind of evidence. I begin where I myself began some 40 years ago with the case of Nicaragua versus United States. The 1986 judgment in that case is one of the first in which the Court took the occasion to elaborate generally on its role as finder of fact. The Court made it clear that, quote, its role is not a passive one. It has freedom in estimating the value of the various elements of evidence. The Court identified two forms of evidence which it regarded as, quote, prima facie, of superior credibility. One, the evidence of a disinterested witness, that is, someone who is not a party. And two, evidence of a party which is against its own interest. It is the first of these categories that is of most interest to us here, the, quote, superior credibility of the evidence supplied by a disinterested witness who is not a party to the proceedings. This is the basis for the Court's reliance on evidence from disinterested third parties, when the circumstances demonstrate to the Court's satisfaction that such evidence has probative value. And such was the case in DRC v. Uganda, in particular with regard to reports by United Nations bodies, specifically reports by the Secretary General and the Special Rapporteur, which were submitted by the DRC and objected to by Uganda. The Court determined that it would consider this evidence because it was appropriate to, quote, give weight to evidence that has not, even before this litigation, been challenged by impartial persons for the correctness of what it contained. On this basis, it found that the UN reports furnished, quote, sufficient and convincing evidence to support the DRC's claims regarding the looting of its natural resources. The Court also placed reliance on the findings of the Porter Commission, a judicial-like inquiry conducted under the auspices of the Ugandan government, to reach its conclusion. Unlike the findings of the Porter Commission, the UN reports were not based on witness testimony taken under oath or subject to cross-examination. In objecting to them, Uganda argued that the United Nations, quote, did not have a mission appropriate to investigations of a specifically legal character, and that its reports were thus, quote, inappropriate as a form of assistance in any assessment accompanied by judicial rigor. If this sounds familiar, it's because it's not dissimilar to the argument that Myanmar makes here in objecting to the Gambia's evidence. The Court rejected Uganda's argument and decided that it would, quote, take into consideration evidence contained in certain United Nations documents to the extent that they are of probative value and are corroborated, if necessary, by other credible sources. In doing so, the Court found that a, quote, a coincidence of reports from credible sources was sufficient to establish that Ugandan forces had committed human rights violations and breaches of international humanitarian law. In particular, it found that the reports of the Secretary General and the Special Rapporteur were, quote, consistent in the presentation of facts, support each other, and are corroborated by other credible sources, and thus constituted what the Court called, quote, convincing evidence. I come next on the tour to the Bosnia case. This morning I mentioned the Court's reliance on the Secretary General's 113-page report on the fall of Srebrenica, as well as on the findings of the ICTY. In regard to the Secretary General's report, the Court determined that, quote, the care taken in preparing the report, its comprehensive sources, and the independence of those responsible for its preparation all lend considerable authority to it. In reaching this determination, the Court noted that the comprehensive sources on which the report relied included interviews conducted on a non-attribution basis with approximately 80 people who had knowledge of the events, on accounts from survivors, on satellite imagery, on other UN reports, on information from governmental sources and NGOs, on information from press reports, and on forensic evidence from the ICTY. In the Croatia case, as I also mentioned this morning, the Court determined that a report by the UN Special Rapporteur submitted by Serbia should be given, quote, evidential weight, owing to the, quote, independent status of its author, and the fact that it was, quote, prepared at the request of organs of the United Nations for purposes of the exercise of their function. More recently, in Ukraine v. Russia, where Ukraine submitted reports by the Secretary General, the High Commissioner for Human Rights, and the CERD Committee to prove that Russia discriminated against Crimean Tatars in occupied Ukrainian territory, the Court, quote, attributed considerable weight to reports of several United Nations organs and monitoring bodies, as well as a report by the Council of Europe. In its 2024 judgment in that case, the Court explained that it, quote, generally ascribes particular weight to reports by international organizations that are specifically mandated to monitor the situation in a given area. The Court has taken a similar approach in its advisory proceedings. Although these are not contentious cases, the Court's advisory opinions are authoritative statements of international law, and the factual predicates for its rulings are often critical. There is no reason to assume that the Court has employed a lower threshold of reliability in assessing the evidence in such cases. In fact, its jurisprudence tells us that it employs the same principles as in contentious cases. In its opinion on the legality of Israel's policies and practices in the occupied Palestinian territory, for example, the Court relied on various reports and statements by UN organs and bodies, including the Secretary General, the High Commissioner for Human Rights, the Independent International Commission of Inquiry, and the Special Rapporteur for the occupied Palestinian territory, explaining that, quote, these reports rely on a variety of sources, including first-hand accounts, to set out a detailed factual analysis of Israel's settlement policy. In the same 2024 advisory opinion, the Court cited as precedent for its reliance on these UN reports its practice in contentious cases, including expressly the DRC, Bosnia, and Ukraine cases. Consistent with its approach in those cases, the Court explained that in determining the probative value of such third-party evidence, it takes into account, one, the source of the item of evidence, for instance, partisan or neutral; two, the process by which it has been generated, for instance, an anonymous press report or the product of a careful court or court-like process; and three, the quality or character of the item, such as statements against interests and agreed or uncontested facts. With regard to the weight to be given to such evidence, the Court considers, one, the care taken in preparing a report, the comprehensiveness of its sources, and three, the independence of those responsible for preparing it. Applying these criteria to the evidence submitted by the Gambia, especially the FFM and the IIMM reports, there can be no doubt of their probative value or that they merit great evidentiary weight. First, let us consider the independence, neutrality, and lack of partisanship of those responsible for preparing these reports. The FFM was an independent body established by the Human Rights Council, composed of 3 prominent individuals, distinguished by their experience and neutrality: Marzuki Darusman of Indonesia as chairperson, and Radhika Kumaraswamy of Sri Lanka, and Christopher Sidoti of Australia as members. A secretariat was recruited by the Office of the United Nations High Commissioner for Human Rights. The core team was composed of a coordinator, a fact-finding team leader, and 5 human rights officers, a legal advisor, a military advisor, a sexual and gender-based violence advisor, a security officer, and 2 language assistants in addition to administrative support. The FFM's members and staff were mandated to employ only, quote, the best practices established for fact-finding missions, as detailed in the OHCHR's published Guidance and Practice for Commissions of Inquiry and Fact-Finding Missions on International Human Rights and Humanitarian Law. The best practices, these best practices, require strict adherence, quote, to the principles of do no harm, independence, impartiality, objectivity, transparency, and integrity, end of quote. Myanmar has produced no evidence that the mission failed to adhere to these principles. Second, in regard to the comprehensiveness of the FFM sources, as I have already mentioned, the sources relied upon by the mission included confidential interviews conducted by the mission or its staff with more than 1,200 victims, witnesses, perpetrators, and former Myanmar officials with direct knowledge of the issues. Satellite imagery, authenticated video and photo material, publicly available admissions of relevant facts by Myanmar officials, laws, policies, and directives of Myanmar, internal Myanmar documents, and statistics, surveys, and other quantitative information generated by Myanmar or the United Nations. Third, the FFM's reports were prepared with diligence and care. As stated in the 2018 report, the FFM carefully assessed, quote, the reliability and credibility of each source, and, quote, considered the information's relevance to the fact-finding work, its internal consistency and coherence, and its consistency with and corroboration by other information, among other factors. In particular, individual cases or incidents contained in the report are based on at least one credible source of first-hand information, which was independently corroborated by at least one other credible source of information. Specific major incidents, such as those set out in Chapter 5 on Rakhine State, are based on multiple accounts from eyewitnesses and victims, allowing for in-depth fact-finding and detailed event reconstruction. Where the report describes patterns of conduct, these are based on multiple credible sources of first-hand information, which are consistent with and corroborated by the overall body of credible information collected. For its 2018 report alone, the FFM, quote, conducted 875 in-depth interviews with victims and eyewitnesses in Bangladesh, Indonesia, Malaysia, Thailand, and the United Kingdom, taking care to, quote, diversify its sources of information by interviewing, quote, individuals from different ethnic and religious backgrounds and a number of members of non-state armed groups, as well as some former officials of Myanmar state institutions, End of quote. For its 2019 report, the mission conducted more than 400 interviews with victims and eyewitnesses. When selecting witnesses, the FFM employed various methodological approaches, including random selection, such as visiting different areas of a refugee camp or different refugee centers without prearrangement, prioritizing those, quote, most recently arrived from Myanmar to ensure the receipt of fresh information, quote, targeting interviewees to corroborate specific incidents or patterns, and striving, quote, to only speak with persons who had not previously spoken with any other organization or media outlet. To further ensure the reliability of the evidence obtained from witnesses, the FFM factored in, quote, the witness's political and personal interests, potential biases, and past record of reliability, where known. The witness's apparent capacity to recall events correctly, considering his or her age, trauma, how far back the events occurred, and so on. The position of the witness in relation to the subject of the information, where and how the witness obtained the information, and the reasons for which the witness provided the information. Myanmar does not and cannot dispute any of this. It cannot disprove the independence of the FFM, the comprehensiveness of its source of evidence, or the meticulous care it displayed in its collection of evidence and the preparation of its reports. Myanmar does not and cannot tell us anything that would diminish the high probative value or the significant evidential weight to which these reports are entitled. Likewise, for the IIMM's reports. The IIMM, too, is an independent body created by the UN Human Rights Council. Its investigations are carried out by experienced investigators, analysts, and legal officers under the strategic direction and oversight of an Assistant Secretary General, Nicholas Koumjian. Thus far, the IIMM has published 6 reports. One on Myanmar's propagation of anti-Rohingya hate speech on Facebook. 2, on its encouragement of Buddhist settlement into Rakhine State to replace or dilute the Rohingya population. 3, on its refusal to investigate and punish gender-based crimes against the Rohingya. 4, on ARSA's weapons possession and use. 5, on Myanmar's abusive detention of Rohingya in Butadong prison. And 6, on its destruction of Rohingya villages. All 6 reports reflect the due care attendant to best practices in international investigations. They plainly meet the court standards, the independence of the authors, the comprehensiveness of their sources, and the care with which they were prepared for giving significant evidentiary weight to UN investigative reports. Mr. President, we do not suggest that the Court should accept and attribute the weight they deserve to the FFM reports and the IIMM reports relied on by the Gambia simply because they were produced by United Nations bodies. The Court is the ultimate finder of facts, and its role is not a passive one. It must determine for itself, in the exercise of its discretion, the reliability and weight of the evidence submitted to it by the parties. Our contention is that applying the well-established criteria for evaluating evidence emanating from third-party sources, as set out consistently in the Court's jurisprudence, it is inevitable that the FFM and IIMM reports be given great evidentiary weight. We note that the joint interveners, Germany, France, Canada, Denmark, the Netherlands, and the United Kingdom have expressed the same view. Specifically, certain sources must be regarded as having particular probative value in establishing the elements required to demonstrate the existence of genocide, including the facts that allow the court to draw inferences as to specific intent. In this regard, the declarants submit that reports generated by the United Nations, such as reports produced by fact-finding missions, commissions of inquiry, and reports that the Secretary General of the United Nations may prepare for the United Nations Security Council or the General Assembly, can have special importance. Indeed, such reports can be particularly credible because they emanate from a disinterested witness. Myanmar alone disagrees. As I said earlier, they take the extreme position that the FFM and IIMM reports have, quote, no evidential weight whatsoever. Zero. Nothing. Rien. Of course they take this position. They know that the 2 FFM and 6 IIMM reports provide compelling evidence that Myanmar committed the actus reus of genocide and acted with genocidal intent against the Rohingya group. Their only hope of avoiding an adverse judgment by the court is somehow to disqualify that evidence. To that end, Myanmar takes 3 different swings at the FFM and IIMM reports. Every one of them misses by a wide margin. First, Myanmar argues that these reports are, quote, incomplete and one-sided because Myanmar itself did not participate in the investigative process. Now, that is far from a convincing argument, but we can't help but be impressed by its audacity. It is true that Myanmar did not participate in the investigative process. But let us not forget that this was because Myanmar refused to cooperate with the United Nations in any way, including by refusing to allow any FFM or IIMM personnel entry into its territory or to accommodate any of their requests for information or access to witnesses. In other words, Myanmar now invokes its own refusal to cooperate to undermine the value of the reports. Yet it is undisputed that the FFM reached out to Myanmar on at least 5 occasions to request in-country access, and it submitted to Myanmar a detailed list of questions to obtain information and documents, and that Myanmar refused to respond to any of these overtures. It is also uncontested that prior to the publication of each report in 2018 and again in 2019, the FFM shared its draft findings and recommendations with Myanmar, offering an opportunity to comment or make factual corrections, and that again, Myanmar made no response. Similarly, as Assistant Secretary General Kumjin attests, as of 17 November 2025, the IIMM had issued 26 requests for information to the government of Myanmar, quote, including information that the Myanmar authorities may deem to be potentially exonerating, such as information on alleged attacks by ARSA. However, quote, the Myanmar authorities have not responded to any of these requests. How can they now complain to the court about allegedly one-sided reports when they have been given multiple opportunities to present their side and review the materials, but they refuse to do so? In any event, both the FFM and the IIMM have attempted in good faith to obtain evidence from sources close to Myanmar that might be supportive of Myanmar's position, including evidence on the nature of the threat supposedly posed by ARSA. And they have included in their reports Myanmar's public statements explaining the objectives and execution of the clearance operations in the Rohingya villages of northern Rakhine State, and denying that their intention was to destroy the Rohingya group. Myanmar's refusal to cooperate with these investigations cannot be a basis for disqualifying or diminishing reports by United Nations body that satisfy all the requirements set by the court for reliability and evidentiary weight. Imagine the precedent this would set if it were otherwise. States accused of serious breaches of international law would have a free pass to avoid accountability simply by refusing to allow international investigative missions into the country and rejecting their requests for cooperation. This appears to have been Myanmar's strategy in this case. It should not be rewarded for its obstructive behavior. Myanmar's second argument is that the court's reliance on the FFM, IIMM, and other reports submitted by the Gambia would be what they call an abnegation of its judicial function because it would amount to a, quote, delegation of its fact-finding responsibilities to other non-judicial entities. They're wrong about that too. We say when the court receives, reviews, and decides to accord evidentiary weight to the report of an independent and authoritative United Nations body, that is a legitimate exercise of its fact-finding responsibility, not an abnegation of it. We are supported in this by the long line of cases I reviewed earlier, in each of which the court determined, upon its own analysis and according to its own criteria, that such reports were reliable and should be accorded due evidentiary weight. Myanmar reads these cases selectively and draws a different, we say, erroneous conclusion. They say the case law establishes that the court may rely on third-party findings only when they result from judicial proceedings, like the findings of the ICTY cited by the court in Bosnia and Croatia, or from judicial-like proceedings, like the findings of the Porter Commission in DRC v. Uganda. They completely ignore the court's reliance on the Secretary General's report in Bosnia, the Special Rapporteur's report in Croatia, and the reports of the Secretary General and the Special Rapporteur, among others, in DRC v. Uganda. Nor do they have an answer for the court's reliance on the reports of the High Commissioner for Human Rights and the CERD Committee in Ukraine v. Russia. Myanmar's argument not only runs counter to the court's jurisprudence and long-standing practice, it also misperceives how the court necessarily conducts its business. The mission of the court is to resolve disputes peacefully between states in accordance with international law. It is not to determine guilt or innocence of individual perpetrators or impose sentence on them. That is the role of the International Criminal Court, which is a criminal court empowered to deprive the accused of their liberty and property, must afford them their due process rights to directly confront and cross-examine the witnesses against them. Those are not the rules of procedure that apply here, and they never have been. Of course, respondent states are entitled to cross-examine the witnesses who do appear in the court to testify against them. But there is no right to exclude evidence obtained from witnesses by authoritative and independent entities, especially UN bodies, whose reports the court, in the exercise of its judicial function, determines are entitled to evidentiary weight. It would be impractical and serve no higher purpose for the rules of criminal procedure to be imported into the ICJ. In this case, it is not disputed that the FFM reached its factual findings after interviewing more than 1,200 victims and witnesses from scores of Rohingya villages where the clearance operations were carried out. If the court could not make findings of fact without hearing the testimony of these witnesses firsthand in the Peace Palace, in a situation where there have been no prior prosecutions by a war crimes tribunal, how many of them would it have to hear to find that the clearance operations were carried out with a similar modus operandi in at least 54 different villages, as the fact-finding mission concluded? That extreme brutality and sexual violence were inflicted in all of these villages. That nearly 200 Rohingya villages were burned to the ground by the Tatmadaw. From how many witnesses would the court have to hear to determine what happened in a single one of these villages, let alone scores of them? In cases of mass atrocity or injury, be it by genocide, war crimes, crimes against humanity, or cross-border environmental catastrophe, hearings involving examination, cross-examination, and redirect examination of the requisite number of witnesses would occupy the court full time, for several months at least. The effect of Myanmar's effort to put a straitjacket on the court in regard to its ability to rely on investigative reports by UN and other authoritative bodies would be to make it all but impossible for the court to hold a state accountable under the Genocide Convention, absent the state's prior submission to the jurisdiction of a war crimes tribunal, an effect which Myanmar apparently does not find inconvenient. I think we can safely assume that it has no intention of subjecting Senior General Hwang and his accomplices to such proceedings. There is no benefit in the approach Myanmar urges you to take. It is true that this court is uniquely a court of first as well as last instance. But why shouldn't the court, in its wisdom and when the circumstances warrant, continue to rely on convincing evidence responsibly and reliably obtained by independent, impartial, and authoritative third-party entities, especially other organs of the United Nations, in making its findings of fact? If the court determines, to quote from its July 2024 advisory opinion, that, quote, the care taken in preparing a report, the comprehensiveness of its sources, and the independence of those responsible for preparing it are such as to ensure reliability and to warrant evidentiary weight, why should the court be precluded from treating it as such? We say, far from an abnegation of its responsibility, this is an entirely proper and necessary exercise of that responsibility, and in many cases, the only practical way in which its job of fact-finding can be done. Mr. President, Myanmar is undoubtedly aware of the weakness of its attempt to turn the ICJ into the ICC, and the improbability of your willingness to redefine your mandate. That is why they expend so many pages of their written pleadings purporting to find technical flaws in the UN reports. In doing so, they give nitpicking a new meaning. For the most part, these alleged flaws are not even nits, but micro-nits, or even nano-nits, where they exist at all. None of them can detract from the reliability of the Gambia's evidence or the evidentiary weight to which it is entitled. For example, Myanmar complains that the FFM's reports fail to set out their methods of work. But in fact, the reports have entire sections dedicated precisely to that purpose, and they confirm that in carrying out their investigation, the mission's members and staff scrupulously employed and adhered to the best practices spelled out in the OHCHR's guidelines. Myanmar also claims that the interviews of victims and witnesses conducted by the FFM, quote, appear to have been cursory. How do they know this if they refuse to participate in the interviews? The answer is they speculate. They say, for example, quote, given the very small size of the FFM staff, it is apparent that the interviews of 875 people in that very short space of time can hardly have been in-depth, and that the process can hardly have been careful and detailed. This is pure conjecture, and it is belied by the facts. According to its 2018 report, the mission deployed to the refugee camps in Bangladesh in September 2017, immediately after the clearance operations had been conducted, and interviewed many of the newly arrived survivors who had witnessed them. Further interviews were conducted during numerous additional field missions between September 2017 and July 2018, which lasted many weeks. For the 2019 report, the mission made 6 field missions to collect evidence between February and June 2019. There is no reason to believe that the amount of time spent or the number of staff involved were inadequate to the task at hand. Again, both reports confirm that the mission's interviews were conducted in conformity with the OHCHR's best practices. Myanmar also attempts to undermine the probative value of the 2018 and 2019 reports on the further speculation that the victims and witnesses interviewed by the FFM were fearful of ARSA and subject to its influence. The FFM did not ignore this possibility. That is why, as stated in its 2018 report, it took particular care not to take the interviewees' statements at face value, but to take into account, quote, the witnesses' political and personal interests, potential biases, and past record of reliability, as well as, quote, where and how the witness obtained the information he or she was providing, and, quote, the reasons for which the witness provided the information. Myanmar offers no evidence, none, that any of the witnesses interviewed by the FFM was in fact influenced by ARSA. Myanmar has much less to say about the 6 IIMM reports. It argues only that they are, quote, not the best evidence of the facts stated in them because they provide, quote, secondhand descriptions of the evidence. But this cannot be a reason for distrusting the reports. All investigative reports, including those on which the court has previously relied, are necessarily secondhand accounts, since the investigators who authored the report are not themselves eyewitnesses to the events that are described. What matters, as the court has explained, is their independence, the comprehensiveness of their sources, and the care they have taken in investigating and reporting the facts. Myanmar has nothing to say about any of this in respect of the IIMM's reports. Instead of attacking those reports, Myanmar criticizes the Gambia for not placing more reliance on them in our written pleadings, suggesting that our alleged omission constitutes an admission that they are not supportive of our claims. It is inexplicable, they claim, that the Gambia has not sought to base its claim on materials provided by the IIMM. Frankly, we don't know what they're talking about. First of all 6 of the IIMM's reports are very supportive of our case. In fact, we annexed 5 of these reports to our reply and quoted extensively from them within it. The only one we did not address was published in September 2025, 16 months after our reply was submitted. You will hear about that one too from my colleagues. I turn next, and more briefly, to the evidence contained in the reports of non-governmental organizations. The Gambia has submitted 50 such reports, including from leading human rights organizations with well-earned reputations for expertise, independence, and objectivity, some of which I identified earlier in my speech. The Gambia does not rely on these reports as its principal sources of evidence, but, consistent with the Court's jurisprudence, as material that corroborates and confirms the evidence contained in the 2 reports by the fact-finding mission and the 6 reports by the IIMM. The Gambia considers it impressive that these reports, more than 4 dozen of them, fully support the factual findings and the conclusions reached by the 2 United Nations bodies. Myanmar cannot credibly object to giving them evidentiary weight because it too has offered into evidence certain NGO reports, including from 2 of the same sources relied on by the Gambia, Amnesty International and the International Crisis Group. Myanmar relies on their reports to support its narrative on ARSA. We, of course, do not object to their reliance on these reports, although we read them differently. In fact, we ourselves have called attention to the following passage from the Amnesty International report that Myanmar submitted as Annex 268 to its counter memorial. Myanmar's security forces, and in particular the military, responded to the attacks and subsequent clashes with an unlawful and grossly disproportionate campaign of violence marked by killings, rape, and other sexual violence, torture, village burning, forced starvation tactics, and other human rights violations and crimes under international law, all of which has been well documented by Amnesty International and others. The military's attacks, which targeted the entire Rohingya population living in northern Rakhine State, have been both widespread and systematic. Nothing can justify such violations. This, I emphasize, is from their evidence. I come next and last to the probative values, the probative value of the witness statements that have been submitted. There should be no debate about the value of the witness statements obtained by the IIMM, which it shared with both parties. As I pointed out earlier, there were 41 such testimonies, of which the Gambia has submitted 12 and Myanmar has introduced 18. The IIMM redacted the names of these witnesses for their protection. Nevertheless, both parties rely on them, thereby waiving any objection they might have to the Court's reliance on witness statements that have been redacted in this manner and for this purpose. As previously noted, the Gambia has also submitted another 48 signed witness statements, 34 in unredacted form, and 14 with the names and other identifying information redacted at the request of the witnesses for their own protection. Notably, none of the statements from Rohingya victims or witnesses were obtained by the Gambia. All were obtained by non-parties to these proceedings. 44 of the statements obtained by the Gambia were obtained by 44 of the statements submitted by the Gambia were obtained by an independent organization, Legal Action Worldwide, which relied on a team of senior criminal investigators, including members of the Royal Canadian Mounted Police. The Gambia submits that these statements, which further corroborate the findings of the UN fact-finding mission and the IIMM, have significant probative value and are entitled to evidentiary weight. As the Court said in Croatia, quote, although some of these statements were made several years after the events in question, they are by victims or eyewitnesses of acts of ill treatment, torture, and rape. The Court gives evidential weight to these statements. Despite this, Myanmar objects to them. It objects to all of the witness statements where the names have been redacted, except, of course, for those on which Myanmar itself relies. In this regard, we refer again to what the court said about unsigned statements in Croatia. Quote, "The absence of signatures of the persons who made the statements or took them does not in principle exclude these documents. However, the court has to ensure that documents which purport to contain the statements of individuals who are not called to give oral testimony faithfully record the evidence actually given by those individuals." That assurance exists here because the statements are in fact signed by the witnesses, with some of the signatures subsequently redacted and vouched for by the entities that took the statements. Myanmar objects in particular to the statements obtained by the Royal Canadian Mounted Police on the ground that Canada is biased against Myanmar due to its intervention in these proceedings, and the RCMP must therefore be regarded as partisan rather than neutral. According to Myanmar, this requires that the statements it obtained be disregarded by the court because, quote, "Canada overtly sides with the Gambia against Myanmar." This is a rather broad definition of partisan, too broad in our estimation. But if witness statements obtained by a party or an intervener are to be disregarded, then the 28 witness statements obtained by Myanmar itself for the purposes of this case and submitted as annexes to its counter-memorial and rejoinder would certainly fall into that category. As the court said in Bosnia, quote, "It will treat with caution evidentiary materials specially prepared for this case and also materials emanating from a single source." In Croatia, the court declined to give evidential weight to statements obtained by the Croatian police, where, quote, "The words used appear to be those of the police officers themselves." Are written statements given under the watchful eye of the Tatmadaw any more reliable? The question answers itself. In contrast to the witness statements obtained by Myanmar, as I have indicated, none of the statements submitted by the Gambia were obtained by the Gambia itself. Mr. President, members of the court, I have given you the reasons why we believe you should consider the Gambia's evidence to be reliable and to merit great evidentiary weight. I trust that this will be of assistance to you as you hear and consider that evidence in the course of these proceedings, commencing with the next speaker. I thank you again for your kind courtesy and patient attention, especially for the second time in the same day, and I ask that you please call my esteemed colleague, Ms. Pasipanoja, to the podium, unless, Mr. President, you